Greeting to you all, ladies and gentlemen. Welcome to Labor Law Education Session. In this session, we cover overview of labor law and employment practices. The goal now is to only cover key concepts and legal frameworks. Labor law can be defined as a legal system that governs the relationship between employers and employees. It helps to ensure fair treatment, rights, and obligations in the workplace. In Chapter 1, we begin by exploring common law, and we do that by studying the contract of employment. We specifically look at two main parts of this contract, namely 1. Nature of location conduction opera rum, contract of service, and 2. Conclusion of the contract. We also look at one more important section of common law within the labor law space, which is the essentialia of the employment contract. Here, we zoom into the specified work, along with the remuneration of the specified work. One other important aspect to consider within the labor law is the conditions of employment where, for example, employees are entitled to vacation leaves and a sick leave. Another aspect is that of the duties of the employers, and we lay them out here in this session. 1. To accept the employee into his service. 2. To provide the employee with work. 3. To pay the remuneration agreed upon. 4. To pay a quantum merit. 5. To provide safe working conditions. 6. To comply with statutory duties. What about employee remedies? Well, we cover them in this session as well. Below is the list. 1. Cancellation. 2. Specific performance. 3. Damages. 4. Refusal of work, and 5. Statutory remedies. Next are employee duties. Employees are expected to fulfill the following duties. 1. To make his services available. 2. To warrant his competence. 3. To obey the employer. 4. To be subordinate to the employer. 5. Maintaining bona fides. 6. To exercise reasonable care when using the employer's property. 7. To refrain from misconduct. Do employers have remedies as well? Yes, here they are. 1. Summary dismissal. 2. Specific performance. 3. Statutory remedies. But what about the termination of the contract of employment? What might be the causes and how should it be executed? This part lists the important aspects to consider. 1. Notice. 2. Effluxion of time. 3. Agreement. 4. Death. 5. Insolvency. 6. Illness of the employee. 7. Impossibility of performance. 8. Cancellation. 9. Redundancy of posts. 10. Completing a specific task. Now let us move our focus to the employer's delictual liability. The following aspects are key elements to consider this employer's delictual liability. 1. Employer or employee relationship. 2. The delict must have been committed by the employee in the course of the performance of his duties. 3. The employer's liability for the delicts of an independent contractor. 4. Restraint of trade. 5. The employer and third parties. That was Chapter 1. Now let us look at Chapter 2, Basic Conditions of Employment Act. This act covers a range of topics, and the following lists the fundamental aspects of the act. 1. Background of the act. 2. Aims of the act. 3. Application of the act. 4. Definitions of terms within the act. 5. Ordinary working hours. 6. Overtime. 7. Compressed working week. 8. Averaging of hours of work. 9. Meal intervals and rest periods. 10. Work on Sundays and public holidays. 11. Night work. Now as we touch the leave rules and conditions within the basic conditions of employment, the following leave types and indirect conditions apply. 1. Annual leave. 2. Sick leave. 3. Maternity leave. 4. Family responsibility leave. Except for the leave, the labor law lists many other factors to consider via the Basic Conditions of Employment Act. The list that will follow are some of many those factors. 1. Particulars of employment and remuneration. 2. Termination of employment. 3. Prohibition of employment of children and forced labor. 4. Variation of conditions of employment. 5. Employment Conditions Committee. 6. Sectoral determinations. 7. Monitoring and enforcement of legal provisions. 8. Legal proceedings. 9. General. 10. Presumption as to who is an employee. We now explore Chapter 3, which covers the Employment Equity Act. We start by introducing some of the concepts to be covered. We list those concepts below. Constitutional equality. The Equality Clause. The Affirmative Action Clause. The Anti-Discrimination Clause. Proof of discrimination. We will explore further to cover the concepts as we learn about 1. Means and ends of affirmative action. 2. The objectives of the Employment Equity Act. 3. Application of the Act. The list has not yet ended. We will also explore concepts like prohibition of unfair discrimination. This is where we delve deeper into the meaning of unfair discrimination, the provision of Chapter 2, and dispute resolution. Affirmative action. Here we worry about affirmative action measures and the duties of designated employers. Commission for Employment Equity. Monitoring, enforcement, and legal proceedings. We cover labor inspectors, labor general, and labor court in this section. Protection of employee rights. Then we conclude it with general provisions. Now we move on to explore Chapter 4, Unemployment Insurance Act. We started off by introducing the definitions and application of the Act. We then lay out the framework of the Unemployment Insurance Act UIF. In doing so, we touch the following aspects: Unemployment Insurance Board, Unemployment Insurance Commissioner, Claims Officers, Director General. Thirdly, we look at the benefits the Act introduces with specific focus on the following items: right to benefits, calculation of benefits, unemployment benefits, illness benefits, maternity benefits, adoption benefits, dependence benefits, general provisions relating to benefits, dispute resolution, enforcement, duties of the employer, miscellaneous. We then close it off with the Unemployment Insurance Contributions Act with specific focus on contributions, interest, penalties and offenses, the application of the Income Tax Act. After Chapter 4, we now focus on compensation for occupational injuries and diseases, which is our Chapter 5. We will dive into 3 main sections for this chapter with main focus on its overview. In our chapter overview we explore the application of the Act, duties of employer, procedure to claim compensation, the right to compensation, compensation, temporary total disablement, in the event of the death of an employee, compensation for occupational diseases, increased compensation. The second section covers more on claiming compensation from the employer or a third party. The last section will be on occupational diseases in Mines and Works Act. Within the same Chapter 5, we will also explore one more section in detail, which is Occupational Health and Safety Act. We will first introduce the section to you, then explore how the Act is applied. We also explore the Advisory Council for Occupational Health and Safety, followed by duties of both employers and those of employees. It does not end there. In the list, we also cover health and safety representatives, health and safety committees, inspectors, miscellaneous, then close it off with Mine Health and Safety Act. Now to Chapter 6, a chapter that covers skill development. Here we give you a brief introduction to the concept of skill development within the labor law. We then move on to touch on the Skill Development Act, where we further explore by first introducing the Act to you. We continue to explore the purposes of the Act, structures of education and training, National Skills Authority, NSA, Sector Education and Training Authorities, SETA, Skills Development Planning Unit, SDPU, labor centers, learnerships, skills programs, financing of skills development, general provisions. This brings us to the third section, the skill development levies to pay, where we talk about things like payment for registration, employers liable to pay, payment of levies, general provisions. Then close it all off with an exploration of the payment of grants. Are you not wondering how we can develop South African labor law? That is what Chapter 7 is covering. In this chapter, we introduce to you structures that are in place to develop the South African law. In that introduction we shall cover National Economic Development and Labor Council Act, establishment of NEDLAC, NEDLAC objectives and functions. We continue by moving to Labor Relations Act, where we cover the introduction to the Act, the application of the Act, and freedom of association. Is there any framework of the Labor Relations Act? Yes, there is. We introduce you to it here, then explore. 1. Introduction to the framework. 2. Trade unions and employers' organizations. 3. Bargaining councils, where we touch processes like establishment and registration of statutory councils. Functions of bargaining councils. Bargaining councils in the public service. There are statutory councils that are established and registered, as we explore them here. We also explore the powers and functions of statutory councils. Now, as we continue with Chapter 7, the development of South African labor law, we now cover 4 more aspects, namely Commission for Conciliation, Mediation and Arbitration, CCMA, Labor Court, Labor Appeal Court, Workplace Forums. To expand more on CCMA, we further explore the establishment of the CCMA, the functions of the CCMA, governing of the CCMA, then the finances of the CCMA. For Labor Court, we dive deep into its composition, jurisdiction, powers, and other general aspects of the Labor Court. In Labor Appeal Court, however, we only explore its composition and jurisdiction. Here comes Chapter 8 to explore collective bargaining within the labor law sphere. In this chapter, we will simply cover the following topics: recognition and the duty to bargain, organizational rights, right of access to workplace, deduction of trade union subscriptions or levies, leave for trade union activities, trade union representatives, disclosure of information, exercise of organizational rights, resolution of disputes about organizational rights. In Chapter 8, we covered collective bargaining, but do you know the structures in place for that? Chapter 9 covers exactly that. We do that by covering 3 main sections here, namely collective bargaining structures, where we delve deep into bargaining councils, statutory councils, workplace forums. The bargaining process. This process covers bargaining unit, bargaining levels, bargaining agenda, bargaining conduct, collective agreements, which explores more on legal effect of collective agreements, agency shop agreements, closed shop agreements, resolution of disputes about collective agreements. Here we go to Chapter 10, which deals with worker participation. We started off by introducing you to the chapter by zooming into 1. Establishment of a workplace forum. 2. Worker participation. 3. Disclosure of information. 4. Matter for consultation. 5. Joint decision-making. This is followed by an exploration to dispute resolution within worker participation in the labor law. We then conclude everything in the chapter by covering dismissals. Before we conclude Chapter 10, we first zoom into dismissals within worker participation section of the labor law. As we zoom in, we touch the following topics: definition of dismissals, automatically unfair dismissal, date of dismissal, requirements for dismissal, substantive fair dismissal, procedural fairness, dismissal for misconduct, dismissal for incapacity, dismissals for operational requirements, Dismissal about fair dismissals. Dispute for unfair dismissals. Transfer of the contract of employment. Ever heard of unfair labor practices? We are covering those practices here in Chapter 11. The following are topics that are covered in the chapter. 1. Definition of unfair labor practice. 2. Promotions. 3. Demotions. 4. Benefit and training. 5. Unfair suspension and other disciplinary action. 6. Refusal to reinstate or re-employ. 7. Probation. 8. Protected Disclosures Act. 9. Job applicants. 10. Dispute resolution. Now, with Chapter 12, we are covering one of the most important aspects of the labor law, dispute resolution. We open the chapter by introducing you to dispute resolution. We then proceed to explore the structures for dispute resolution. Thirdly, we touch on dispute resolution by councils where we further explore the concepts of 1. Accreditation. 2. Jurisdiction of council. 3. Referral of dispute to council. 4. Subsidies, fees and confidentiality. Can CCMA also embark in dispute resolution? Yes, and we zoom into this here in this chapter. We focus mainly on the following items to uncover more about this. 1. CCMA jurisdiction. 2. Conciliation. 3. Arbitration. 4. The arbitration award. 5. Power of CCMA commissioners. Alright, before we formally conclude the chapter, we touch on 3 other aspects of dispute resolution. Those 3 aspects are 1. Con-arb, that is conciliation and arbitration. 2. Pre-dismissal arbitration. 3. Dispute resolution of specific disputes. What about strikes and lockouts? Chapter 13 explores that with you. We have 4 main sections to cover in this chapter. We start by introducing you to the right to strike, the definition of strike, the prohibited strikes, absolute limitations on industrial action. We then extend our understanding of strikes by exploring essential service, where we zoom into the maintenance service and protected strike. Our third sections help us explore briefly the consequences of a strike. We conclude the chapter by other forms of industrial action where we explain the following phenomena. Secondary strike. Picketing. Protest action to promote or defend socioeconomic interest. Strikes or lockouts in response to impending retrenchments. Determining the nature and status of industrial action. Lockouts. The last chapter of our labor law education, Chapter 14, touches briefly on labor relations in public service. Here we only talk about 2 main sections, namely, bargaining councils in the public service, and dispute resolution. With all that content, we close the labor law education and thank you very much for your time.